Hello, everybody, and welcome to Law and Society. Today, we're going to go over Jack Smith's motion in Judge Chutkan's court for a narrowly tailored protective order because of what Donald Trump has been saying to the public through his posts. So, if you're new to my channel, please like and subscribe, and let's dive into it. I will take any questions that you have afterwards. So, for now, I will not check the chat. So first, what I'm going to do is I'm going to read you some of the headings from this motion, and then I'll read you a few excerpts of what Jack Smith is asking. Mind you, this sort of a protective order of what he can say. It has to adhere to the First Amendment protections so as to not infringe on Donald Trump's First Amendment rights, because every defendant has First Amendment rights. We all have First Amendment rights. So the biggest hurdle here is for Judge Tani Chutkan to outline and lineate what Donald Trump can and cannot say to the public. So Jack Smith's motion reads thus. The defendant has a history of inflammatory and misleading statements that he knew or should have known would cause others to harass and harm perceived critics or adversaries. There's some redactions here. Since the indictment, the defendant has deployed misleading and inflammatory statements about this case to undermine confidence in the justice system and prejudice the jury pool. That includes posts attacking, undermining, and attempting to intimidate the court and the jury pool. And then Jack Smith puts up all the messages that Donald Trump has posted on Truth Social. Posts attacking, undermining, and attempting to intimidate prosecutors. And then there are, again, the deranged Jack Smith Donald Trump posts. And there's more to talk about. Posts bolstering or attacking and attempting to intimidate witnesses. And there are several posts from Truth Social that is part of this complaint. So remember, anything Donald Trump says in public can and will be held against him in a court of law. And this is a very good example of Jack Smith not taking it anymore, not just laying down and letting Donald do it anymore. He's bringing it to court. He's asking the court to chalk out a very narrowly tailored protective order about what can and cannot be said about this case. The defendant's public posts regarding this case are reasonably likely to prejudice the jury pool. The court should ensure that public statements by the defendant and his agents do not prejudice these criminal proceedings. The court should issue an order pursuant to Local Criminal Rule 57.7c that prohibits certain narrowly defined statements. The court should issue an order that prohibits contacting the citizens of this district to conduct jury studies without first notifying and receiving authorization from the court. And then Jack Smith concludes by saying, consistent with its obligations to guard the integrity of these proceedings and prevent prejudice to the jury pool, while respecting the defendant's First Amendment rights, the court should enter the proposed orders imposing certain narrow restrictions on the parties' public statements regarding this case and governing any jury studies the parties may undertake. So I pretty much read you the headlines of every section. So now what I'm going to do is read a few excerpts from Jack Smith's motion that over and over presents evidence and points out where and what Donald Trump did that would cause the jury to be influenced and for there to be intimidation of witnesses, jurors, prosecutors, judges, and other court officers. In asking for the protective order, Jack Smith says the defendant's conduct presents a substantial likelihood of material prejudice to these proceedings, and the court can and should take steps to restrict such harmful extrajudicial statements. The defendant engendered widespread mistrust in the administration of the election, and individuals whom he targeted were subjects to threats and harassment. The defendant knows that when he publicly attacks individuals and institutions, he inspires others to perpetrate threats and harassment against his targets. The defendant continues these attacks on individuals precisely because he knows that in doing so, he's able to roil the public and marshal and prompt his supporters. As he acknowledged in a television town hall on May 10th, 2023, his supporters listened to him like no one else. So using Donald Trump's words here against him. Since the indictment in this case, the defendant has spread disparaging and inflammatory public posts on Truth Social on a near daily basis regarding the citizens of the District of Columbia, the court, prosecutors, and prospective witnesses. In his posts on this topic, the defendant repeatedly makes the knowingly false claim that the special counsel's office prosecutors went to the White House in advance of the defendant's June 2023 indictment for improper reasons. They didn't go to the White House. Defendant's objective is spreading a known lie to the contrary, including by reposting others' Truth Social posts, naming the prosecutor and repeating the lie, is an attempt to prejudice the public and the veneer in advance of trial. Through such posts, the defendant is attempting to submit his false and inflammatory claims to the public and the jury pool outside the court. Such claims made before the court will fail because they must be supported by evidence, of which there is none. So Jack Smith makes clear that Donald Trump is litigating this case in the court of public opinion and thereby undermining the case that is ongoing in the court of law in Judge Chutkan's courtroom. If unfettered, the way the defendant is known to use public statements to intimidate individuals could affect potential jurors. The government proposes two narrowly tailored orders that impose modest permissible restrictions on prejudicial extrajudicial conduct by the parties and counsel. The government seeks a narrow, well-defined restriction that is targeted at extrajudicial statements that presents a serious and substantial danger of materially prejudicing this case. The defendant's repeated posts that he cannot receive a fair trial from this court or from a jury of his peers in this district are substantially likely to undermine confidence in the justice system, affect the jury pool, or otherwise prejudice the due administration of justice. The government respectfully requests that the court set forth a process to review efforts by either party to engage in contacts with members of the jury veneer in this district, undertaken for the purpose of discussing case-specific facts. Such an order is consistent with the court's inherent authority to protect the integrity and fairness of the judicial system through preventing comments that are likely to prejudice the jury veneer. And then the conclusion: to guard against the integrity of these proceedings and prevent prejudice to the jury pool, the court should enter the proposed orders imposing certain narrow restrictions on the parties' public statements regarding this case and governing any jury studies the parties may undertake. So as you see here, as you see in the motion, Jack Smith is extremely specific about what the gag order, what the protective order needs to be. And Donald Trump will have a few days to respond. As he has before, he will respond with a bombastic reply with no evidence whatsoever. And Judge Chutkan will therefore have to grant the protective order. I believe that this protective order needs to be granted. It's months overdue. And so we'll have to wait for Donald Trump's reply and then see what Judge Chutkan does. Remember, Judge Chutkan's removal motion is also ongoing at the moment. So, oh, hello, I see somebody from Donald's side saying he's going to be president again. Yeah, you can keep hoping. Good luck.